Read over some of these examples in Chapter 5 that deal with legal liabilities. So for this one, we have an audit engagement partner, Mark Johnson, recently received a subpoena for work papers related to audit engagement on which the audit firm has been named the defendant. Mark asked the staff auditor to remove and discard 2 memos from the work paper files documenting communications between the engagement partner and the CFO regarding goodwill impairment analysis. So work papers are allowed to be subpoenaed, and in most states they have to give those to the courts if there's an issue. So that part's all fine. What is not fine is that he asked the auditor to remove and discard 2 memos from those work paper files. So that's intentional, and that would be fraudulent. And then actually Sarbanes-Oxley came in and said, hey, if anyone is, like shredding or destroying documents in those audit work papers, that can actually be a criminal charges could be filed. So that's very bad. Okay, then number 2, Chad Lewis is the lead audit partner on an audit engagement of a publicly traded company. Chad followed auditing standards on the audit engagement and issued an unqualified opinion. It was subsequently discovered that the financial statements contained a material misstatement that had been undetected by the management of the company and by the audit team. So in that case, he followed the audit standards on the audit engagement and issued an unqualified opinion. He had no knowledge of the material misstatement, nor did the company. So he really exercised due care and followed a prudent person's standards. So he is not negligent. Again, we go back to say the audit is not a guarantee. It doesn't prove that everything's been looked at 100% and there's no material misstatement. I mean, that it can happen. So in this case, just unfortunately it happened, but he followed all the rules. Okay, then number 3, we have Maria is a CPA and a sole proprietor. She recently accepted a new audit client that is applying for a bank loan and needed to present audited financial statements to the bank. Maria was not able to complete the audit engagement by herself because, again, she's a sole proprietor, so she hired several college students to assist her. The students completed the audit procedures without much guidance, and then Maria issued an unmodified opinion on her client's financial statements. So in that case, she is negligent. So she violated the standards of like the human resources standards that you want to put the right people on the audit. You want to supervise their work, and then have like somebody obviously who's going to sign off on it and double check it. Doesn't sound like she did that. So even though she did not have the intent to deceive, it still would be considered constructive fraud because she didn't actually follow the generally accepted auditing standards of the supervision and the competent employees. Okay, then number 4, we have a recent audit engagement. The client neglected to inform the audit firm that a significant percentage of the inventory was stored in an outside warehouse. As a result, the auditors did not observe the physical count for that inventory, which represented about 20% of the client's inventory balance. And the auditors, though, were able to satisfy themselves that the inventory existed through alternative procedures, and they issued an unmodified opinion of the financial statements as a whole. So we talked about this. So in a sense, their scope was limited because they did not realize there was inventory at an outside warehouse, so they didn't observe it. So when you have those scope limitations, like we would have said, they maybe would have had to not issue an unmodified opinion, but they're allowed to come up with alternative methods to make themselves feel comfortable that that inventory did exist. So they did that. So they were able to satisfy themselves with those alternative procedures. So then it was okay. They are not negligent. They followed what they should have done, and they went ahead and issued the unmodified opinion on those financial statements. So all is well with that one. Then our last one, Melissa is a lead engagement partner on a publicly traded company, and the company's CEO recently approached Melissa and informed her that they had identified a material misstatement in the prior year financial statements that had been audited by Melissa's firm and submitted to the SEC. The CEO suggested that they correct the misstatement by recording a journal entry in the current year for half of the amount of the misstatement and then take the following year for the remaining half. Melissa agreed to this plan to avoid the public announcement of a restatement and a potential lawsuit, since the amount of the journal entries recorded in the current and subsequent years would be considered immaterial to the financial statements. So clients do ask for that kind of stuff, so they call it smoothing the earnings. Do you know what I mean? So instead of saying, hey, I don't want to take this big hit this year and I don't want to go back and restate last year, well, I recognize that we made a mistake. Let's put it in this year and then we'll put the rest in next year. So it'll just kind of smooth through and nobody will really know about it. So unfortunately, though, even though clients want to do that kind of stuff, Melissa, as the lead partner on this audit engagement, cannot say yes to that. So she can't agree to that plan. She needs to say no. So because she didn't and she agreed and made the entries, then it is fraudulent activity because she knowingly is deceiving the users of the financial statements. So she should have said no. Okay, so that is some examples again of the legal liability side of things.